Hello and welcome everyone to yet another lecture of company law. In this lecture, we are going to discuss about a technical topic in terms of types of companies, which is foreign company. Many students find this a bit technical, but we are going to make it very easy. In this next 15 minutes, we are going to discuss right from the definition of a foreign company, when are the provisions of Companies Act applicable to a foreign company, and what are the provisions for punishment in terms of contravention of the provisions of the Companies Act which are applicable to such company. So without wasting any time, let's get started with the topic of foreign company. So when we speak about foreign company, many students feel we are speaking about a global brand like Apple or Samsung. But under Indian law, the term is very specific. We aren't just looking at where a company is born or where a company is registered or where a company is incorporated. That is not the only criteria to say that a company is a foreign company under the Companies Act. The most important part is whether the company is incorporated outside India and where does it has an place of business. If the place of business is in India, then we can say that such company can qualify as an foreign company. Let us first start understanding what a foreign company is as per the Companies Act. So the definition of the foreign company has been provided under section 2 clause 42 of the Companies Act 2013. So what does this definition say? Definition is very simple. It only says that any company or any body corporate which is incorporated outside India, okay, which is incorporated outside India. So body corporate incorporated outside India, okay, which has a place of business, in India. So if a company is registered or incorporated, say in London, okay, and it has a place of business, in Mumbai, so such company will be included in the definition of foreign company. So when we are speaking of place of business, we will go into the depth in a bit, but place of business can be by itself or through an agent, physically or through electronic mode also, okay. And the second condition, so the first condition is that the place of business should be there within India, okay. It can be through itself or through its agent, or in terms of physical presence, or in terms of an electronic presence also. The second condition to a foreign company's definition has been provided is that it conducts any business activity in India in any other manner. It conducts any activity of business within India. So not only the place of business, but it should also have an activity of business within India. So if both these conditions, so condition number 1, condition number 2, condition number 1 and condition number 2 both have to be satisfied. So that is why it is called as a two-pronged test. Matlab, both the conditions have to be satisfied to become a foreign company. Okay, say if a company is incorporated outside India, okay, but it does not have a business activity within India, so then it is not qualified as a foreign company, but it will be called as a company which is incorporated outside India. So the provisions of the Companies Act will not be applicable to such company. Whereas the another scenario, if a company is incorporated outside India, but it does not have a place of business in India. Be it in electronic mode, digital presence, or even physical presence. In that case also, the company will be said to be incorporated outside India, but not coming under the definition of foreign company. Hence, the Companies Act will not be applicable. So this definition is clear. Definition has 3 parts to it. 1, body corporate, which is incorporated outside India. Second, it has to have a place of business in India. Third point is Third, that is the second condition is company shall be conducting a business activity in India. Now, when we speak about place of business, let us understand the place of business also once. Okay, when we say about place of business, it does not only mean an four-walled office, which we also call as brick and mortar office. It isn't just a brick and mortar office, but it can be physical. It can have a physical presence in terms of a four-walled office as well as in terms of electronic mode. For example, say a company like Google has its registered office in US, incorporated in US, and it has a place of business in India. Let's say Hyderabad. Okay, so it has an office in Hyderabad. So that is a physical presence that the company is having within India. So it qualifies as an foreign company because it also does provide business services within India. Okay, so the other part is, say a company like streaming company, like say for example Netflix. Okay, Netflix has registered or incorporated in the US. Okay, but it has a place of business in India. Yes, and it is also providing what? It is also providing streaming services in India. So it might not have a physical office in India, but it has a place of business in India, and it is also providing streaming services, that is digital presence is there within India. So it will also qualify as a foreign company. Is this clear? Is this clear? So physical presence as well as electronic mode has to be there. Now electronic mode, it is broad. It includes B2B, B2C. B2B means business to business, business to consumer transactions, data storage, supply chain management, or even offering digital services to Indian citizens, such as streaming service or an e-commerce site, like we can say Netflix, or you can say e-commerce site like say Amazon or an eBay. Okay, such examples are available within India. Okay, now let us move to the provisions which are there. Before that, the first foundation provision is given under section 379. Okay, under section 379. And what does 379 say is that 379 states when and what provisions of Companies Act will be applicable to a company which qualifies as a foreign company. We just understood what is a foreign company, what are the conditions, and if those conditions are met, then such company qualifies as a foreign company. Okay, qualifies as a foreign company under the Companies Act. So it will have to comply with the provisions of the Companies Act. Now section 379 states which provisions of the Companies Act has to be complied with such foreign company. Okay, so the first point that it says is that section 380 to 386, section 380 to 386, and section 392 to 393. These are the provisions which have to be complied with a foreign company. Okay, it is applicable to all foreign companies. That is the point number 1. Now, point number 2 interestingly brings another concept into this foreign company discussion. The concept is of a deemed Indian company. Now, what do you mean by deemed Indian company? And listen to me very carefully now. Okay, say there is a foreign company. Okay, for example, there is a company called as Desi Global. It is incorporated in Singapore. And it qualifies to both the conditions of foreign company under section 2 clause 42. Hence, Companies Act is applicable. Now, section 379 says that Companies Act is applicable. So, along with that, since in this company, that is Desi Global, around 51% of paid up share capital, is held by, say, Mr. Anand Mahindra. Okay, so he is an Indian citizen, and he is holding 51% of paid up share capital in Desi Global, which is incorporated in Singapore. So such foreign company where an Indian citizen has more than 50%, more than or equal to 50% of paid up share capital, or any Indian company which is incorporated under the Indian Companies Act is holding 50% or more of paid up share capital of such company, or a combination of such citizen and body corporate both milke, that is they in totality have how much, 50% or more of the paid up share capital of such company, then in that case such company will be deemed to be Indian company, so it is incorporated outside India, but because more than or equal to 50% of the shareholding is held by an Indian citizen or Indian company, then in that case it will be deemed to be an Indian company. Now you will say, what does it mean? What kind of an significance this kind of provision has? The significance in terms of applicability. What applicability will be for an Indian deemed Indian company is that not only the provisions of this chapter, that is chapter 22, which is from 380 to 393, not only those, but the whole of the act, the whole of the provisions of the Companies Act as is applicable to Indian company will be applicable to such deemed Indian company. So deemed Indian company, if in a foreign company more than or equal to 50% of the paid up share capital is held by one or more Indian citizen or one or more companies or body corporate incorporated in India, or a combination of both. What do you mean by combination of both? Say Mukesh Ambani is holding 26% plus Reliance Industries is holding 26%. So a total of 52%. So what does this mean? If an Indian citizen plus an Indian company holds more than or equal to how much, 50% of paid up share capital in such company, then such foreign company will be deemed to be Indian company. Okay. Now we have understood the concept of deemed Indian company. Now we will also understand that for such a deemed company must comply with the provisions of chapter 22, which is the foreign company, okay, and all other provisions of the Companies Act as if it were a company incorporated in India. This is very, very important from the exam point of view. Okay, in a case study such kind of question may come where they will provide the paid the shareholding of that company, it is incorporated outside India, and what is the significance in such company, what is the applicability of law in such company. Such kind of question can come in the exam, and in that case you have to state this section 379 subsection 2 over here. Okay, so not only chapter 22, but the 22 is 380 to 386 plus 392 to 393. Not only these provisions but also all provisions applicable to Indian companies registered or incorporated in India will also be applicable to such deemed company. Applicable to such deemed Indian company. So we have understood the topic of applicability. Now we have seen that section 380 to 386 is applicable and 392 to 393 is applicable. Now let us understand the gist of these sections also one by one. First of all, we go to section 380. Now what does section 380 speak about? Section 380 says that any such company, such foreign company, when it establishes a place of business in India, then within 30 days, within how many days? Within 30 days. Within 30 days of establishing a place of business in India, the company must deliver to the ROC, the following documentation. Okay, it will be registering itself as a foreign company with the ROC by providing such following documents. What are the documents? One, it has to provide a form FC1, form FC1. Okay. Second, it has to provide a certified copy of its charter or statute, which in India is known as Memorandum of Association or Articles of Association. In countries outside India, it is normally known as a charter or a statute of that particular company. So a certified copy of such charter or statute has to be provided. Now, if the charter or statute is in a vernacular language, like the language which is prevalent in that particular country, like say from companies incorporated in Italy, so the charter is in Italian language, then along with the certified copy and translated copy should also be provided to the ROC. Okay, that's the first point. Second point is the full address of registered office outside India. Full address of registered office outside India. Like say this Italian company, so the registered office in Italy has to be provided, and at the same time the place of business, the registered address of the full address of the place of business in India has to also be provided. Okay, so this is the address part. Third part is the company has to provide the list of directors and the secretary of the company. List of directors and the secretary of the company and all their details also, like the address, their whatever identification documents will be there, that also has to be provided. And one more important and interesting part is that the foreign company, when it starts a place of business in India, it has to appoint a person who is resident in India as its authorized representative. Now, why is this required? One, it is required for any legal notices that has to be provided, that has to be given to the company, or any communication that has to be given to the company. Then this authorized person will be the person who will be receiving such communication from say courts or from any other entities in India. Okay, so that is why an authorized representative who is a resident in India has to be appointed. Okay, so authorized representative is also clear. Now, the next point, this was section 380 in totality. Okay, so as soon as a company establishes a place of business, it has to provide form FC1. Along with that, it has to provide charter or statute of the company. It has to provide the list of the directors. It has to provide the full address of the registered office in that country where it is incorporated and the place of business in India. And it has to appoint an authorized representative. That is, this is provided in section 380 of the Indian Companies Act 2013. Okay, this one section 380 is clear. Now section 381 speaks about accounts and audit. Now, what do you mean by accounts and audit? Such company, like any other Indian company, every financial year has to prepare a balance sheet and profit and loss account. Has to prepare a balance sheet and profit and loss account for its Indian operations. So separate balance sheet and a separate profit and loss account will be created for the Indian operations. It has to file a copy with the ROC along with the list of places and places of business established in India. So it will file the annual return, which will include the annual financial statements, and this has to be provided within 60 days of the end of the financial year. Okay, so this was section 381. Next we go to section 382. Now, what does section 382 says is that, very simple, that the company, wherever it has a place of business, it should conspicuously exhibit its name along with the place or country where it has been incorporated. So company must conspicuously exhibit its name and the country where it is incorporated outside every office in India. It must also state this on the letterheads, bills and notices of the company, that the company is communicating with any other entity or within the organization. Okay, so this is 382. So we have now gone through 379, 380, 381, 382, Okay, now the next one, let us understand it from a practical illustration also, like say a scenario where a company which is Nordic Tech Limited, company's name is Nordic Tech Limited, it is incorporated in Norway. This is Norway in Europe where it has been incorporated. Okay, now this company, this Norwegian company has started an representative office within India, and it is registering it as a place of business, and it will be conducting an business activity in India. Hence, it qualifies under section 2 clause 42 as a foreign company. Okay, so once it becomes a foreign company, it has its registered place of business in Mumbai. So it will appoint an authorized representative. Okay, so the requirement is within 30 days of opening that Mumbai office, they must file form FC1 with ROC. This is provided in section 380. Okay, providing details of the Norwegian headquarters. Norwegian means Norway headquarters, and their Mumbai office address. Mumbai office address because it is a place of business in India. They must also appoint Mr. Sharma. Sharma is an example. Mr. Sharma, a resident in India. Now this authorized representative has to be a resident in India. This is very, very important. Okay, as the legal representative for Indian authorities. Okay, so you understood this illustration. I think whatever explanation I have done so far, the illustration is already self-explanatory. Okay, now there are some additional provisions that I want to cover. We have covered up to section 382. One more important section is section 384. Now what does section 384 speak about? Section 384 says that there are many provisions of the Companies Act which are applicable to the foreign company as it is. Apart from chapter 22, there are many provisions of the Companies Act which are applicable to the foreign company as it is, which is called as mutatis mutandis. What is it called as? Mutatis mutandis to the foreign company. Some of them are like annual return under section 92, which is filed by the Indian company. Similarly, it is filed by the foreign company also. There are some necessary changes which have been done to these sections as per the foreign company, and it has been provided that several provisions of the Companies Act 2013 applicable to Indian companies apply mutatis mutandis to the foreign company. One of the examples is section 92, that is filing of annual return. The other one is the books of accounts maintained at the principal place of business in India for the business transacted in India. This is under section 128. Section 128 is also nearly applicable to the foreign company. If I give more examples, then it is like the provisions of charge is also applicable to a foreign company. Then if I give one more example, like the provisions for debentures, that is section 71. If the foreign company wishes to issue debentures within India, then in that case section 71 will be applicable to the foreign company. So in case this is a very not a very important point, but it may come for the exam in terms of which provisions are applicable to a foreign company, which are applicable to Indian companies also. Give examples, so you can give this 3-4 examples over there. Okay, now next point is about section 393 and section 392. So if a foreign company fails to comply with the provisions of this chapter, is which chapter are we speaking about over here? Chapter 22. Okay, chapter 22. So provisions, which provisions are we speaking over here? Section 380 to 386. Okay, if the foreign company does not comply with the provisions of this chapter, in that case there are two provisions which have been provided. One is section 392, the other is section 393. Okay, 392 speaks about punishment for contravention to the company and the officer in default. Okay, and 393 speaks about what is the effect of non-compliance, which you can call it as a like a disability clause which has been put by the Companies Act, where what is the disability that the company would face in case it is non-compliant to the provisions of this chapter. Okay, so first let us understand the disability first. It is like a strategic disability. Now, what do you mean by strategic disability, and why do I call it as a strategic disability? It is because what happens is that if a foreign company does not comply with the provisions of the Companies Act, or Chapter 22, in that case, any contract which the company has entered into, okay, it will lose the right to sue upon such contract, and it cannot enforce such contract against any other entity. So any transaction, any deal, or any contract that such a company has entered into, it will lose the right to sue. It will lose the right to sue. Right to sue will be lost by the such company. So it cannot enforce any contract, deal, or transaction in an Indian court. Okay, this part is clear. So does it mean if it cannot enforce a contract that it has entered into, does it mean that the contract is invalid? No. Contract will still be valid, and any other entity, that is an Indian entity, can drag the company into the Indian courts and sue the company. So the company will lose the right to sue, but can be sued for the same contract. Are we understanding? So what does the provision say? However, such non-compliance does not make these contracts invalid. So very, very important from the exam point of view. Case study can come on this point also. Okay, so once again I will explain. If a company does not comply with the provisions, then in that case company loses the right to sue. So it cannot enforce any contracts, transactions, or deals it has entered into in the Indian courts. Okay, at the same time, any other company which has entered, the other party which has entered in the contract, can sue the company for its non-compliance or for its non-performance. Okay, so such contracts are valid, but it cannot be enforced by such company which has defaulted. Okay, so foreign company can be sued. The foreign company can be sued by others, and liability remains intact. Very, very important from the exam point of view. Okay, now in terms of contravention, what is the punishment that has been provided? That is given in the section 392. Now 392, very simple section. It says in case of company, the fine of 1 lakh to 3 lakhs can be imposed. 1 lakh to 3 lakhs. Okay, and for a continuing offense, then in that case a fine of 50,000 rupees per day will be imposed. 50,000 rupees per day will be imposed. Okay, like say for example, a company has not filed the annual return. Okay, the due date is passed. Now once the due date is passed, there is non-compliance, and hence due to this non-compliance there can be a fine of up to 3 lakhs and the minimum of 1 lakh. Okay, now every day that passes that the non-compliance continues till they actually file the annual return, till that period, every day there will be an additional fine of 50,000 rupees. This is what is known as continuing offense. Okay, so this part is clear. Now in case of officer in default, the fine is 25,000 rupees to 5 lakh rupees. Okay, so I hope this is also clear. So in summary, I would say any company, any body corporate which is incorporated outside India, okay, it has a place of business in India, and it is doing some kind of business activity in India, then it will qualify as a foreign company under section 2 clause 42 of the Companies Act. This is the first thing. Second, the presence can be physical or it can be even electronic. Okay, for example, we saw the like say Google, which has a physical presence. At the same time, electronic presence can be like a company like Netflix or Amazon also. Okay, now in terms of activity, must conduct business in India. It must file form FC1 within how many days? Within 30 days of starting the place of business in India. Okay, and it should also appoint an authorized representative who should be a resident of India, who should be a resident of India. Okay, and it must file the annual accounts for Indian businesses separately. A separate balance sheet and profit and loss account has to be filed within 60 days of the end of the financial year. Okay, so I hope this concept of foreign company is absolutely clear to you. Go through this video a couple of times, you will be able to understand everything. Do let me know your feedback on this video, whether you have understood this topic or there are some gaps which are there. Do ask your doubts in the comments below. I would be happy to solve them. And let me know if any other topics that you want me to be covered in a specific video, then I will make a specific video for that particular topic also. Okay, in case you found this useful, do share it with your friends and like the video, subscribe to the channel. That is what gives me the motivation to go on. I have a bit of an difficult schedule, so that is why some inconsistency in terms of uploading videos are there, but I would try to increase the frequency of my videos going forward so that it helps all of you in terms of concept clarity. Chalo then. Bye bye.